What are the necessary documents, and who are the necessary witnesses of plaintiff in suit for preemption? Number 1. Plaintiff's title document to establish his right of preemption, such as shafi khalit, shafi sharik, and shafi jar. Number 2. Defendant's title document such as mutation or sale deed through which he purchased the suit property. Number 3. Notice of Talb-e-Ishahd. Number 4. Receipt issued by post office for dispatching notice. Number 5.
Acknowledgement Due.
Number 6. Documents to establish price of suit property if ostensible price of suit property is written to defeat right of preemption. Now the question arises, how these are to tendered or filed in court. The answer is simple. None of these documents are per Southeast permissible, nor the court can take judicial notice. So these documents are to be proved and brought on record by the plaintiff through the statements of those who are signatory or scribers. However, since there is never dispute as to the title document or mutation of defendant through which he purchased the suit property, so such document is to be filed by plaintiff in his statement. Reason is obvious as admitted fact need not to prove. But the plaintiff shall file his own title document and notice of Talb-e-Ishahd in his own statement and identify his signature on it. The attesting witnesses and scriber shall also identify their signature on such notice. Here a very important fact is to be noted and brought on record through the order of the court. That is, if the notice is not served on defendant and same is returned, the plaintiff has to file such sealed envelope in court with the plaint, and it shall be opened by the orders of the court and then exhibited. If it is not sealed envelope, suit shall not succeed. If it was served on the plaintiff, then through an order of the court, it is to be filed by the defendant and then exhibited in statement. If defendant refuses to file such notice or states that it was not received by him so he is not in his possession, then the plaintiff has to prove its delivery, and then by orders of court, he shall file copy of such notice as secondary evidence. The receipt shall be exhibited in the statement who issued it. Acknowledgement due is to be brought on record through the statement of postman. In case the plaintiff challenges that the actual price of suit property is lesser than the shown in sale deed or mutation, and excessive or ostensible price is written on such document to defeat his right of preemption, then plaintiff has to prove such fact by producing relevant person and documents showing the price of properties sold in the vicinity in relevant times. Keep it in mind clearly that such documents, if brought on record through the statement of counsel, shall remain not proved. Last but not the least, these documents must be filed in examination in chief so that defendant had an opportunity to cross the witnesses on these documents.